Oregon has one of the most heavily regulated tenant screening environments in the country, matching or exceeding California and Washington in the depth and specificity of its screening restrictions. If you're screening tenants in Oregon, you're operating in a legal framework that caps fees, restricts criminal history usage, mandates source of income acceptance, and imposes detailed procedural requirements at every stage of the process. Compliance is not optional. Oregon's enforcement environment is aggressive, and penalties are significant. Let's start with application fees, because Oregon has some of the most specific fee regulations in the nation. Under ORS 90.295, landlords can charge a screening fee, but the fee is capped at the landlord's actual average cost of screening applicants. The landlord cannot charge more than the customary amount charged by tenant screening companies for the type of screening conducted. Oregon's fee provision goes further than most states. The landlord must provide the applicant with a receipt for the screening charge. If the landlord doesn't actually conduct the screening, for example, if the unit is already rented, the fee must be refunded. And, critically, the landlord must provide the applicant with written notice of the screening criteria before accepting the fee and the application. This upfront disclosure requirement ensures that applicants know what standards they'll be evaluated against before paying. The written screening criteria must include the minimum income requirements, the credit criteria, the criminal history criteria, the rental history criteria, and any other factors the landlord considers. Oregon law requires this disclosure to be specific. Vague statements like "good credit required" are insufficient. The landlord must identify the actual standards, such as a specific credit score threshold or a specific income-to-rent ratio. If the landlord fails to provide the screening criteria before collecting the fee, or if the criteria are too vague, the applicant may be entitled to a refund, and the landlord may face liability. Oregon also has a unique provision regarding the order in which applications are processed. Under ORS 90.304, landlords must process applications in chronological order. First come, first served. The landlord cannot cherry-pick from a pool of applicants. The first applicant who meets all of the landlord's stated screening criteria must be offered the unit. This chronological processing requirement is unusual and significantly affects how Oregon landlords manage the application process. If the first applicant meets your stated criteria and you reject them in favor of a later applicant, you face potential liability, unless you can document that the first applicant failed to meet a specific stated criterion. This makes having precise, documented screening criteria even more critical in Oregon than in other states. Criminal history screening in Oregon is heavily restricted under ORS 90.303. Oregon enacted comprehensive criminal history screening reforms that impose specific limitations on how landlords can use criminal records. Landlords cannot consider arrest records that did not result in a conviction. Landlords cannot consider convictions that have been expunged, sealed, or set aside under Oregon law. Landlords cannot consider juvenile records, and Oregon imposes specific look-back period limits. Landlords generally cannot consider convictions older than 7 years, with exceptions for certain categories of offenses, including sex offenses and offenses involving manufacture or distribution of controlled substances. Oregon requires landlords to conduct an individualized assessment when considering criminal history. The assessment must consider the nature and severity of the conviction, the time elapsed since the conviction, the applicant's age at the time of the offense, evidence of rehabilitation, and the relevance of the conviction to the tenancy. The landlord must consider any supplemental evidence the applicant provides, including letters of recommendation, completion of treatment programs, employment history, and other evidence of rehabilitation. If the landlord denies the application based on criminal history, the landlord must provide written notice that includes the specific conviction forming the basis for the denial, and an explanation of how the individualized assessment factors were applied. Portland has enacted even stricter screening requirements under its Fair Access in Renting Ordinance. Portland's rules add additional procedural requirements and limitations beyond state law. Landlords operating in Portland must comply with both state and local requirements, and where they conflict, the more restrictive rule applies. Source of income protection in Oregon is well established and strongly enforced. Under ORS 659A.421, landlords cannot discriminate against applicants based on their source of income, including housing choice vouchers, Social Security, disability payments, veterans benefits, and any other lawful source of income. Oregon's source of income protection is comprehensive. Landlords cannot reject applicants because they receive vouchers. Landlords cannot advertise that they don't accept vouchers. And landlords cannot set income requirements that effectively screen out voucher holders when the voucher plus the tenant's income would cover the rent. The Bureau of Labor and Industries, known as BOLI, enforces source of income protections and investigates complaints. For credit reports, Oregon follows FCRA requirements for permissible purpose and written consent, plus the state's additional disclosure and procedural requirements. The adverse action process must comply with both FCRA and Oregon's specific notification provisions, including the detailed criminal history denial notice when applicable. Oregon also has a provision regarding tenant screening reports. Under ORS 90.295, if the landlord obtains a tenant screening report, the landlord must provide the applicant with a copy of the report upon written request. This is a state-level right that goes beyond FCRA's standard provisions. FCRA gives applicants the right to obtain their report from the Consumer Reporting Agency, but Oregon gives them the right to get it directly from the landlord. Oregon's fair housing protections under ORS Chapter 659A are among the broadest in the country. Protected categories include race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, marital status, and source of income. The breadth of protected categories, combined with Oregon's detailed screening procedures, creates one of the most restrictive screening environments in the nation. Oregon also has specific protections for victims of domestic violence, sexual assault, and stalking that affect the screening context. Landlords cannot deny an application based on the applicant being a victim of domestic violence or based on incidents at a prior tenancy attributable to the perpetrator. From a practical standpoint, Oregon's rental market is concentrated in a few population centers with dramatically different dynamics. Portland is by far the state's dominant rental market. The Portland Metro, including Beaverton, Hillsborough, Gresham, Lake Oswego, Tigard, and Clackamas, is driven by technology. Intel's massive operations in Hillsborough, along with hundreds of other tech companies, healthcare, Nike's world headquarters, Columbia Sportswear, manufacturing, and the creative economy. Portland experienced dramatic rent increases during its growth period, followed by some moderation as new apartment construction added supply. Portland's screening environment is the most restrictive in Oregon. The city's Fair Access in Renting Ordinance adds requirements on top of the already strict state law. Portland landlords must navigate both layers of regulation, and the city actively enforces its ordinances through the Office of Community and Civic Life and through private complaints. Portland's tenant advocacy community is one of the most organized and active in the country. Organizations like the Community Alliance of Tenants and Oregon Law Center provide legal assistance to tenants and actively pursue screening discrimination complaints. Landlords in Portland should assume that non-compliant practices will be identified and challenged. Salem, the state capital, has a more moderate and affordable market driven by state government, healthcare, and agriculture. Eugene, home to the University of Oregon, has a tight market driven by the university and a strong quality of life appeal. Eugene has been active in tenant protection discussions and may enact additional local requirements. Bend has experienced explosive growth driven by outdoor recreation, tourism, technology, and remote workers. Bend's market is tight, with high rents relative to its size. Corvallis, home to Oregon State University, has a student-influenced market. Medford-Ashland in southern Oregon has a moderate market driven by healthcare, agriculture, and tourism, though the region's wildfire risk has affected housing dynamics. The coastal communities, including Astoria, Newport, Lincoln City, and Coos Bay, have smaller markets with seasonal tourism influences and limited housing supply. Screening in these communities often involves applicants with variable or seasonal income, and landlords should have clear criteria for evaluating non-traditional income sources. Military presence in Oregon is relatively limited. No major active duty installations generate significant rental demand, though the Oregon National Guard and Reserve components are present throughout the state. One critical best practice for Oregon landlords: invest the time to create detailed written screening criteria before you list a single unit. Oregon law requires you to share these criteria with every applicant before collecting a fee. Your criteria must be specific, not vague. Identify your exact credit score threshold, your precise income-to-rent ratio, your rental history standards, your criminal history evaluation process, including the individualized assessment factors, and any other standards you apply. Have this document professionally prepared and ready to distribute. In Oregon, vague or undocumented criteria aren't just bad practice, they're a compliance violation. Another critical best practice: implement the first-come, first-served processing requirement into your workflow. Develop a system for tracking when each application is received and process them in strict chronological order. If the first qualified applicant meets all your stated criteria, you must offer the unit to that applicant, regardless of whether a later applicant appears more desirable. Deviating from chronological processing exposes you to discrimination claims. A third best practice, for Portland landlords specifically: layer Portland's requirements on top of state law and use the combined requirements as your compliance baseline. Don't try to maintain separate Portland and non-Portland procedures. Instead, adopt the most restrictive standard for all your Portland properties and train your team on the full set of requirements. Oregon limits the security deposit to the equivalent of 1 month's rent and requires the deposit to be returned within 31 days of the tenant vacating. Prepaid rent, including last month's rent, is treated separately from the security deposit. The deposit limitations make compliant, thorough screening essential. Your financial protection through the deposit is minimal, so getting the tenant selection right is critical. For the complete guide to Oregon tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.